Yep. Okay. Okay. Good. We're ready to go. Welcome to the Newcastle Institute meeting for May 2023. Some old faces and some new faces. All welcome. I'm Ross Kerrie. I'm one of the committee of the Newcastle Institute. For those, we welcome those in the audience and those who are live streaming or watching this in delayed broadcast from our website or Facebook, where we loaded up in the night of the presentation so it can be watched delayed. And we know people around Australia and indeed internationally watch it both live stream and from the web. So the Newcastle Institute was formed in 2004 and we've been going since then. We like to suggest that our effort is about presenting diverse ideas and promoting rational discussion, but without taking a position on any particular topic. And so people say, well, what does that achieve? And you wonder, but I think just promoting rational discussion of diverse ideas is a good end in itself, particularly given what's been going on in the world of late. But it does lead on to things, and reflecting in 2011, one of our forums was entitled The Church and That Problem, and we had Joanne McCarthy and a Catholic priest discussing the problems that were becoming more well known about what had been going on within the Catholic Church and other groups. And at the end of the discussion that night, there were people saying this needs to go further, and people were saying there needs to be a Royal Commission about this. A group in Newcastle convened another meeting the next year, further discussing that, and it was accompanied by a campaign almost from the Newcastle Herald. And ultimately, I think that did lead on to Julia Gillard's last act as Prime Minister of convening a Royal Commission, for which we know where that went. So, yes, it does go places. The Newcastle Institute sees Newcastle as a place where for thousands of years there has been learning and sharing of ideas. And that starts with the Awabakal and the Worimi people, but all those who have followed on from them, and we are the inheritors of a great tradition of sharing ideas and looking after and building the community. And we're proud to continue and recognise those who went before us and continue that tradition. So our topic tonight is about as sensitive as it gets. The issue of sexual assault, and we know that there's a problem, there has always been a problem. Is that problem increasing? Certainly is increasingly reported, but at the same time, a feeling that the current system for dealing with sexual assault is unsatisfactory. So we want to have a discussion about that. And we've got a panel of speakers that really could be unsurpassed, I think, with different perspectives and different views, but not necessarily opposing views, but just different perspectives, which is what we like. We've found when we present people just with opposite views, nothing much happens. They just get entrenched, throw mud at each other, and nothing much happens. And so we like to have a discussion fostering a range of ideas, and that's what we're going to have tonight. So our speakers, Catharine Lumby, Professor of Media and Communication at Sydney University, who's had a very interesting involvement in this topic over the last 20 years, and we'll have some interesting stories to tell in that regard. Catharine is also someone who comes from Newcastle originally, so yeah, great, but has come up from Sydney for the night. Kerrie Thompson is the CEO of VOCAL, that's Victims of Crime Assistance League, which is a service in Newcastle and the Hunter that acts to help, as the name would suggest, victims of crime, and thus has a particular perspective from the perspective of the victims and those with lived experience of sexual assault. Annie Cossins is Professor of Law at University of New South Wales, and in fact has just written a book which I gather is very good, particularly for those with a legal brain, which I certainly don't have, but I gather it is a very good book, suggesting that we need to change from the adversarial legal system to perhaps a more inquisitorial legal system, and I think that will be one of the topics that we'll be exploring in more depth. Simon Harbin SC is a very experienced barrister in Newcastle, has worked in both Crown prosecution and for the defence, and will obviously bring to the discussion his broad experience of the legal system in all its majesty and misery. Is that a fair enough? That was a nice alliteration on the fly. Yeah. And then the format of the night, Cathy, Kerrie and Anne have brief presentations introducing some of the things they wish to talk about, and we're then going to go into a panel discussion which will be facilitated by Greg Bullard, a solicitor and former barrister in Newcastle, who'll be playing the role of, if you like, Tony Jones in the discussion between our four experts and incorporating questions or short comments from the floor. So without further ado, I'll start with Catharine. Would you like to do your presentation?
Sure. Thanks, and I won't talk for very long. I just thought I'd give you a little bit of an insight into. Well, I mean, I think I probably got into this space. A friend of mine, Janet's sitting here, and can you hear me? Speak up. Speak into the microphone more. Okay. So, I mean, even I think at primary school, I would have considered myself a feminist. When I was 7, I remember asking for an orange plastic model of the Apollo landing ship, which my parents duly bought me, and no one explained gender politics at NASA at the time. But anyway, I sat in there fantasising about being an astronaut. So I've always been interested in gender equality. Into the microphone. I was worried it was echoing. No, okay, that's better. A little bit, okay. So I come to this discussion and conversation as someone whose main expertise has been advocacy and listening to people who are advocates, but also doing research and education in the space of how to prevent and how to manage and how to address sexual assault and mistreatment of women. And so I'm going to use this little case study, which is the work I did with the NRL. So this is a page from the Daily Telegraph that goes back probably to about 2005. So in 2004, there was an allegation of a group sexual assault of a woman at Coffs Harbour by the Bulldogs team, an NRL team. And David Gallop, who was the then CEO, called me up. I was at Sydney Uni as a baby professor then, and said, could you come and have a chat to us about what to do? And I said, well, mate, you don't do anything till you know what's going on. So I ended up leading a large research team out of Sydney University, and we did interviews and surveys with over 200 players. We did all the CEOs, the boards. We did top-down, bottom-up stuff. And we found out a lot, and I would say there's probably 200 front pages for the Daily Telegraph in my head that we found out. We also found out, as I already knew, having grown up in Newcastle, that a lot of the guys who play league are good guys. There was a male bonding culture, some of which I would describe as toxic, that goes back a long way. And so on the basis of this research, we started to design education programs. But I want to give you a little snapshot about what it was like when I came into this space, because one of the things I think's changing is we're going through a cultural reckoning about how women and children are treated when it comes to sexual assault, how the courts treat them, domestic violence. All of these issues now are things that the majority of Australians are much more educated on. Just in the same way they're more educated on climate change, they're more educated on First Nations people and their history and what we owe them and what happened to them. I think on a range of issues we see Australians becoming more and more informed and more willing to have these debates and discussions. But I want to show you what it was like back then, because it was a little bit of a shock, actually. I didn't anticipate when you put rugby league, sex and feminism together, it's a bit of a pressure cooker. So these are the sort of headlines that were happening at the time, right? And they sort of dropped me in and announced I was going to be their gender advisor, right? Now, this did not go down so well in some quarters. So you can see Wendy McCarthy, Quentin Bryce, myself and a number of other women put together a sort of symposium when we invited the players and coaches and other people along to explain the research we were going to do. And you can see how happy these blokes look going into this, right? So that's number one. This is like, the sort of narrative was, we've brought a feminist in from a university, like the worst kind of person you can imagine, right, to tell these blokes what to do. And so this is Andrew Bolt. Some of you may know of him. He continually is concerned about his lack of freedom of speech, even though he has a syndicated national column, I believe a radio show and a television show. But apparently he's very concerned. And I'll just read this to you. I'll move the mic this way. Or actually, can I use this mic? Yeah. Okay. It says, Catharine Lumby accuses dull people like me of moral panic, but I can't help it. When the National Rugby League hired her this week to deal with its sex scandal panic is exactly what I felt. I thought, is this how civilization ends? With funky academics telling a league harried by claims of a pack rape that morality is a dirty word. Now, that's... Actually, this is probably easier to use. That is kind of interesting to me, because the way that he's framing it is in terms of morality. And one of the first things I said to David Gallup, apart from you need to know what's going on, is that the worst way to proceed is to get a whole bunch of these guys in a room and tell them they're all bad, they're all toxic, they're all dangerous, all men are rapists, potentially, you know, which puts women in the role of moral police, you know, and it doesn't understand the nuances and the messy business of human sexuality, and it is a messy business. There are grey areas. It doesn't mean that anyone deserves to be sexually assaulted. But that was a sort of framing, and I think this is Miranda Devine, just another example. As if the Canterbury Bulldogs Rugby League club wasn't already in a pickle, now it has been saddled with a gender studies expert. So, you know, there was this sort of idea that, well, there are immoral men out there who sexually assault women, and then there's the rest of the men. And it misunderstands fundamentally, I think, the fact that we still live in a very gendered society, that sexual assault is about an assertion of power. And these are conversations that we've started to have. And when we look at the Women's March on Parliament, when we look at, unfortunately, the Brittany, well, it's not the Brittany Higgins case, she is the person alleging assault, but when we look at how she's been treated and put in the spotlight, we know there are a lot of things wrong with redressing and addressing the problem of sexual assault. And now you can see how happy I was by the end of that media week. It's a very happy look on my face. But this is the final thing I'll say, is that being a former journalist, I was a print and TV journo for 20 years, I actually realised that I had a secret weapon. I was a mother, and mothers cannot be bad. So you can see how I've it's a form of child abuse. I've dragged my attractive-looking children into a photograph, and suddenly it's all good. Right, so I'll leave you with that thought. But what I'll finish by saying is you'll hear a lot more about the statistics on sexual assault, which unfortunately a large proportion of includes children. Most sexual assault survivors are female, not all of them, of course. Annie's the person with the absolute statistics here. I had stats written down and I'm concerned to use them because as I finished reading her book in the car on the way down, I went, oh my God, I might have got this wrong. But we do know that very, very few cases, that not enough cases go reported, that when they do, very few are prosecuted and very few result in a conviction. And we know that the legal system is fundamentally broken in many ways, but Anne and others on the panel have ideas about how to change things. And I'll finish by saying Anne's book, Anne Cousins' book, Closing the Justice Gap for Adult and Child Sexual Assault, is one of the best books I've read in 2 decades on the subject. She talks about the importance of a trauma-informed approach, about mandatory training of court personnel in trauma-informed approaches, about the whole set of issues with cross-examination, the issues with the jury system and the way that rape myths are persistent. We will be talking about that more, what they are. The role of restorative justice, and I think the whole question of is the jury system effective, what would an inquisitorial model look like? So I'll shut up and hand over.
Kerrie, sorry, we back on this mic? Yeah, you happy using this? Okay.
Thank you. Thank you. Okay. Thank you for having me. The Victims of Crime Assistance League was established in the Hunter region in 1989 after Beresfield local girl Tracy Gilbert was murdered by her ex-boyfriend. Now, Tracy's parents started Vocal as a homicide support group to help people who were going through the criminal justice system because they themselves experienced some pretty terrible responses and they didn't want any other families to go through that. Over the years, we've been lucky enough to be able to extend our support to all people impacted by violent crime. And today, the majority of our work with victim survivors and their families is of homicide, physical assaults such as stabbings, glassings, assaults with weapons, sexual violence, and what I'm going to talk about today is predominantly the experiences of adult survivors, both male and female, home invasions and domestic and family violence. So some people who have accessed our service have reported to police, others want information on how to report to police, and some don't want to report to police at all. We have a support specialist co-located within the Waratah Police Station, Belmont Police and Raymond Terrace Police Station. We've had that for 2 years on 1 day a week so that we can sort of help facilitate people who may need a little bit of extra support when dealing with police. We work from a trauma-informed perspective and we're really trying to work out what supports and interventions are available for people post-crime, and that can include relocation, can include safety planning, accessing counselling, financial assistance, and helping people stay engaged with employment or education so that they're not withdrawn from society. Now, sexual violence creates some very complex challenges that survivors are forced to navigate both in their personal lives and within the criminal justice system. But before I speak about survivors' experience within that system, I just want to highlight some of the common emotional reactions and responses that sexual assault victim survivors experience. And this can happen at the time of the assault, or what we're finding, it's triggered through the criminal justice system, or they're often long-term mental health issues. So that can include shame, embarrassment, fear, anxiety, grief and loss, resentment, anger, betrayal, shock, overwhelm, irritability, limited concentration, and feeling hypervigilant or on edge. Not all survivors who report sexual assault want the matter to end up in court. It's really, really important to remember that. Everyone has their own reasons for reporting sexual violence to police, but all survivors do want recognition, validation, and an acknowledgement of the harm that's done to them. So I'm just going to outline the process of reporting to police. I don't know if anyone has had the pleasure of going into a police station. It's quite overwhelming, but I'm just going to give you a general overview. Sometimes we go, and even with us there, the responses aren't so great, but this is from years and years of working with survivors. So you walk into a police station anywhere in New South Wales, and you go up to the front desk, and they say, "Can I help you?" And you might say, "I want to report an assault." And they say, "What kind of assault?" So this is in the waiting room. There might be people there, a line behind you, and you sort of lower your voice and you say, "Sexual assault." And they go, "Oh, tell us what happened." Now, the responses here do vary. It depends on who you get at the front counter. There's no process that police have to follow. It depends on how busy they are, how their resources are at the time. So some people will take the report over the counter. So you give your name, your details, essentially a little bit about what happened, who did what, when, where, why. Some police will take you into a room, those ones that are a little bit more trauma informed, and say, "Come off to the side," and they'll sit you down and they will talk about, okay, what I need today is some basic details, and then after that a detective will contact you. But pretty much you give an overview of what happened. There's no support provided. Often there is no links to support services from police. And you're told to pretty much go on your way, and a detective will contact you at a later time. Now, a detective may contact you a week later, or it might be several months, depends on their workload. They ring you out of the blue and they say, "Do you want to come in and make a statement?" So the statement, a formal police statement, is the really hard to talk about stuff. It's the details, what happened before, during, and after the assault. It can take several hours, it can take a day, it can take multiple days. And many women, particularly women, find it extremely difficult to sit in a police station with a man they have had a conversation with over the phone and talk about some very intimate and personal details. We often advocate that a support person needs to be provided at this time. However, some people are happy to do their statement on their own. Others do need that support person. Essentially then they go, the detective's, "Okay, we'll have a look at it, we'll be in contact." And that is quite often the time where a lot of negative mental health things happen, because a survivor walks out of the police station, they've just told their most traumatic experience, and there's no support. Many people say that that's the most vulnerable time for them. They feel very alone and very isolated. Now, I've been lucky enough to witness over the years some amazing trauma-informed responses from police, local police that we have in the Hunter region, and even in that time their validation and acknowledgement of the harm done can really shift a survivor's perspective, and help them move forward from what's happened. But I've also seen and heard some pretty not so great responses. And this includes what he did wasn't that bad. There must have been some good memories you've had of him. Are you sure you want to go ahead with this? He could lose his job. And the one that's more often than not said, it's your word against his. It's going to be hard to prove in court. And this is probably the main one where people come back to us and go, "Why am I even bothering?" So with some pretty solid advocacy, we've been able to create some local change within especially the Newcastle region, and I'm going to talk more about that when we have our panel discussion. But as we know, a lot of sexual survivors, their reports don't make it through the criminal justice process due to lack of evidence. Now, lack of evidence doesn't mean it didn't happen. It just means that the police cannot get the evidence to meet the criminal charge. And if a matter can be investigated, what we're finding, especially up here in the Hunter region, is it takes years for it to be investigated and get through the criminal justice process. One local matter we had that was finalised last year lasted 4.5 years from the time the victim reported to the time the offender was sentenced. And he pled guilty in that case, so if it had gone to trial, it would have, reached the 5, possibly 6 year mark. It is well known that the court system does not treat sexual assault survivors kindly. During cross-examination, many experience victim blaming, feeling harassed, intimidated, bullied, and some even report that the court process is equally as traumatising as the assault itself. Our support through the criminal justice system involves helping survivors to depersonalise this extremely personal experience. Whilst giving evidence, I've witnessed women cry, sob, vomit, shut down, yell, argue back, and even walk out of the witness room during cross-examination. Pushing people to absolute distress should not be how our justice system is allowed to function. Survivors have no control over what the criminal justice system is going to determine about their matter, but we must empower people to get justice in different ways. So a lot of our work with victim survivors is talking about what do they want out of reporting. Some people report a crime and that's their sense of justice. They've had their voice. Some people go through the investigation process and are okay that there's no criminal charge because someone has taken the time to look and investigate, possibly spoken to the alleged offender, and that's enough for them. But others want their day in court, and we have to manage those expectations. So in closing, the criminal justice system does not adequately respond to the needs of sexual assault victims. Most people working in this space have known that. The system is broken. We've known that for decades. We must fight for a legal system that does not add trauma to already traumatised victim survivors. Thank you.
Thank you for that. I must admit, I'm speechless with what you've already told me. I was unaware of that. Anyway, okay. Annie Cossins, Professor of Law at University of New South Wales and recent author of a book that at least one person has read and thinks is pretty fantastic. And
thank you.
Sorry, I'll just...
it's an e-book.
And I didn't bring any copies, so... Well, thank you. It's been great just to listen to both of you thus far. Just a bit of background. My whole academic career has been spent lobbying for and writing about, and sometimes successfully getting reforms to the way that sexual assault is prosecuted in New South Wales, and sometimes the reforms that I've lobbied for or I've jointly written have been adopted right around Australia. So I've had lots of wins, but I guess since 1999 I've been doing this work. The more I've done it, the more I've realised how a lot of the reforms that have been introduced and which maybe I thought would make substantial changes, really tinkering around the edges. So in 2020 I published a book. It was like my final word on the whole topic, but it's a long book, so it was a lot of final words. And I was, it was a task that I set myself. I had a great publisher who who wanted another book from me, so I said, yes, okay, this is what I'll do. So the task that I set was, how can we deliver real justice for complainants in sexual assault trials? In other words, how can we achieve best evidence for vulnerable witnesses? And I decided to look at both child sexual assault and adult sexual assault trials. There are many similarities, but also many differences. So the book contains, it's basically a compilation of hundreds of studies that have been done right around the world that confirm, not only in New South Wales, but England, other states and territories of Australia, the US, that the main basis of any sexual assault trial, including those involving children, they're based on rape myths and other misinformation that dominates not only the questioning of the complainant, but dominates the trial from the beginning, from the defence's opening address to the jury to the defence closing address, and sometimes is even picked up by the trial judge and repeated in the summing up. So the aim of rape myths during a sexual assault trial is to basically create a dichotomy between supposed real rape victims and how they behave, compared with the complainant's actual behaviour during or after the alleged sexual assault. Even though these myths, we know, are just that, they're not actually based on any scientific or medical evidence. So there's a very specific cultural context that's created within an adversarial sexual assault trial. And that cultural context is based on victim blaming, because the complainant is made out to be responsible for the defendant's behaviour, and this is done in subtle and not so subtle ways. For example, the fact that she was dressed in a certain way, she was out at night. They're just subtle suggestions. Sometimes they're direct, sometimes they're more subtle. How much did you have to drink? Wasn't that a lot for a woman your age? Those sorts of things. Do you normally take drugs? Do you normally walk down dark streets? Do you normally get into men's cars alone? All of those sorts of things are all about her behaviour, and therefore the hope by the defence is that consent will be implied, that because she behaved or dressed in a certain way, the defendant can't be responsible for what he did. So by painting the complainant's behaviours as abnormal and therefore morally questionable, the trial turns into a trial of the complainant's moral worth, which undermines her credibility in the eyes of both the judge and the jury. So we don't really know how many wrongful acquittals have occurred over the years because of the permitted use of rape myths in sexual assault trials, and that's the problem. They are permitted. So, the lawyers in this room know that any evidence or questions put to witnesses have to be relevant, and relevance is something that is assumed because our culture for hundreds of years has been based on always questioning women's morality, their sexual behaviours, their drinking behaviours, their etc. So that a woman who is painted in a certain light inevitably becomes morally questionable. But the question that I posed in my book is, should myths, stereotypes and other inaccurate information about how a complainant ought to behave, should those things be allowed in trials at all? So in answering that question, I documented the fact that the types of behaviours that defence counsel rely on to undermine a complainant's credibility are actually many of the symptoms of trauma as a result of being sexually assaulted. And to that I would add that many adult complainants of sexual assault it's quite a frequent phenomenon that they themselves have been sexually abused as children. So having been sexually abused as a child or adolescent makes people more vulnerable to being sexually assaulted as adults. Something that very few people know about, though, is that the unfairness of sexual assault trials also arises in relation to what is known as the cross-examination effect. So there are dozens of studies that show, they were firstly carried out with children, that cross-examination questions in and of themselves, and what I'm talking about here is leading questions with complex syntax and vocabulary, they significantly affect children's accuracy about actual events, in that in all these studies a majority of children have been shown to change truthful evidence into inaccurate evidence when cross-examined. So the question then arose, well, do adults respond in the same way? Unfortunately, a later series of studies showed that adults also struggle to understand linguistically complex questions, and that they are also susceptible to leading questions, especially if they are repeated again and again. And we also need to understand that, and probably start accepting that in a sexual assault trial, whether it's a child or an adult, it's a vulnerable victim because of the trauma associated with that particular assault. So studies have shown that adults will change their truthful answers to less accurate answers under cross-examination style questioning, which therefore reduces the accuracy of their evidence and therefore inevitably leads to accusations of lying or fabricating their evidence by the defence. But one of the aspects of cross-examination and the trial process in and of itself is that there are inherent triggers within an adversarial trial process, and these triggers are amplified during cross-examination, and they cause complainants to re-experience the emotions associated with the original trauma. Now, anyone who's done any research on the brain at all will know that when a person is emotionally overwhelmed, certain other aspects of the brain are not available to them. That is the capacity for logical thought, for logical thinking, but also the capacity for understanding and comprehending questions. So I don't know if any of you have been traumatised at all, or anxious, or been in an exam where everything you thought you knew just went out of your head, and that's an example of being emotionally overwhelmed. The problem is that these triggers and the particular vulnerability of complainants and the cross-examination effect is something that very few, if any, judges, lawyers and lay people really know about. Also, what I've found is that legal professionals and lay people are generally ignorant of the fact that sexual assault is the most common cause of PTSD and trauma-like symptoms, so that we can expect that most, if not all, complainants who go through the court process, not all will exhibit classic PTSD symptoms, but they may re-experience some of the trauma-like symptoms that they experienced during and after the alleged assault. So after many years, I became firmly convinced that in Australia we needed fundamental reforms to the sexual assault trial. Firstly, to prevent the use of rape myths by defence counsel, but also to reform the cross-examination process, to ensure that complainants are not re-traumatised during that process, and to enable complainants to actually give their best evidence, not their worst evidence, because of the emotional trauma that they are re-experiencing. So I think basically we need measures to move from a justice system that triggers and exploits a complainant's trauma. And if you talk to defence counsel who frequently appear in sexual assault trials, they will privately admit that they are aware of how to exploit a witness's trauma, whether it's the complainant or any other witnesses. And I think that we need to move to a system that is trauma-informed, that seeks to minimise and prevent trauma. So I've shown that it's possible to transform the sexual assault trial into a system that treats complainants as traumatised individuals. A trauma-informed system would do no further harm. I think that should be our basic aim, and would seek to understand the psychological needs of each complainant to ensure that their best evidence is able to be given rather than being impeded. A trauma-informed sexual assault trial would specifically understand not only the impact of sexual assault on an individual, but would also understand the intense and re-traumatising nature of the courtroom. And this can be a variety of things that most of us as lay people wouldn't think about. So it can just be the court precinct, the court building itself. It can be coming into contact with the defendant as they walk in the vicinity of the building, or the defendant's friends or family. It can be just the imposing nature of the courtroom. It can be the gowns and the wigs worn by judges and barristers. It can be the actual court layout itself, which emphasises structures of authority. And it can also just be the court personnel. So there are sheriffs, there are police, right at the entrance where you go in, and you're not actually frisked, but you walk through that X-ray thing. And then, of course, the complainants have to, probably for the first time in their life, undergo the processes within an adversarial trial, which, when it's a sexual assault trial, are specifically designed to catch them out, to make them look less credible, and to exploit their psychological vulnerability. Now, there's no doubt the lawyers in this room will have a million questions about, well, how do you transform the adversarial trial into a trauma-informed system? It's actually not that hard, but, that's about another 100 pages of my book. There are some precedents for it in the US. For example, trauma-informed trials are conducted in some states in the US in relation to custody matters, for example. I do know that in Scandinavian countries they've done away with direct questioning of complainants by defence counsel, and they have a specialist examiner who undertakes that role and who puts questions to the complainant on behalf of the defence. So there are ways, none of which impede the rights of the defendant, because the trial needs to be fair to the defendant. But the concept of fairness, we now recognise, extends to witnesses and complainants in sexual assault trials, but we don't yet have the processes in place to ensure that it is a fair and just system for complainants. Okay, I'll leave it there. Thanks.
Let me go with this one. Yep. That's got it. Okay. Thanks. That was a great presentation. Just to explain, our fourth panellist, Simon Harbin, SC, isn't giving a presentation, but will bring his vast experience of being at the pointy end of the legal system over the years into the discussion. So I'll now hand over to Greg Bullard, who'll facilitate the discussion from here. Rob and I will be around later on. We'll be taking questions from the floor or comments from the floor. And so, Greg, thank you for doing this. I should say, Greg stepped up on Monday to fill in, to help us out in this role. So, thank you again.
Before going any further, I'd just like to acknowledge if there's anyone here tonight or anyone tuning in who has lived experience with sexual assault, that we extend our compassion to you. And while we're talking about things in such a clinical way, we're doing that to try and flesh out some of these issues, and we certainly hope that we're not causing you any distress by speaking about them in such a clinical or academic way. So I've got some questions here, but most of those questions have been answered in the presentations. So Simon didn't get a presentation in, but Simon is in a unique position as an eminent senior counsel in New South Wales who has both prosecuted for the state of New South Wales as well as defended. So Simon, if you'd just like to make some general observations on how sexual assaults are played out in the courtroom, and just maybe give us some of your thoughts or impressions.
Thank you. Can you all hear me? One of the things that stood out in what was said a little while ago was that there's a problem with the system long before you get to a courtroom, e.g. reporting to the police. It's available when someone wants to complain about something that is yet to be established. Okay, thank you. It takes me back to when I first started doing some prosecution work, bearing in mind that most of my criminal work has been on the defence side. But I received a brief as an acting Crown prosecutor, and I read it, and it was a very awful, serious case. And I read it, and I spent about 3 pages jotting down all the things that were missing from the prosecution brief to prove the case. So I rang the Crown and I said, look, you're never going to win this case, which was a week or 2 weeks away, bearing in mind that you had the whole process of event, complaint, investigation. In those days, we had a preliminary hearing for a magistrate. You get to trial years later, and here I am at the heel of the hunt saying, can't win this case because it's not been prepared properly. Now that's got nothing to do with the system per se. It's got to do with those people who are entrusted to do their job. In a week and a half, we got the trial properly prepared, ran it, and there was a conviction. But that wouldn't have happened if that work wasn't done. This isn't an answer to the question that's being posed here tonight, but it does speak to the fact that there are all sorts of things that can be done to make any system better. I've never been involved in any research project about this area. My research has come from 40 years practice at the bar. I'm sorry I didn't get to read Professor Cozen's book, which I've heard about tonight, and I'll do so, because despite my natural inclination to persist with the system we have, with or without change, I'm certainly interested in the process and how we can make it better for all of the parties involved. And that includes complainants, people who are accused of crime, those who surround these people, and those who work in the system. It's not satisfactory in a lot of ways, but from my point of view, and this goes against the grain of what's been said tonight, I think there have been some real changes that have made Defence Counsel think their job is harder to defend these cases now. And bearing in mind also that when we talk about this subject, this is a very complex subject involving many moving parts. A lot of what was said tonight, for example, could be directed to the question of consent, which raises entirely different issues to other parts of proving cases in other types of allegations. For example, whether or not something happened or it didn't happen. And I must also say that I don't think I've ever in all my years utilised or taken advantage of someone's trauma in cross-examination. I would think that would be improper, and I would rely on the people who oppose me in court to object, and my experience of good judges is that they'd be very quick to close that down, and more particularly so I think in the last 5 to 10 years that would be the case in my experience.
Thank you very much. The next question will touch on to that adversarial system, and most of you would realise that our legal system is what's known as an adversarial system. Most European countries use what's called an inquisitorial system. They're quite different, and I'm sure academics would say that there's flaws in each of those systems, but one thing that immediately comes to mind when I think about this is the words of the former Director of Public Prosecutions for New South Wales, Mr. Nicholas Cowdery, who said that justice is only served when the combatants at the bar table are of equal capability. And that's a good starting point now just to ask Dr. Cousins, do you think there is room for an inquisitorial type system for specific criminal offences such as sexual assault?
Well, I'll try that one, Sean. At the end of, I'll go back to the end of 1999. I and a district court judge from Queensland set up a committee to look at that very issue, and it was a 10-year long committee, if you like. We met for 10 years, and on that committee there were other district court judges from other jurisdictions. At the time, every Director of Public Prosecutions was on the committee. There were children's commissioners and various academics, and I was tasked by the committee, I was the chair, but I was also tasked by the committee to consider everything, and our brief was reform, what are all the possible reforms required to the child sexual assault trial. So we were focused on children, not adults. And they asked me to consider everything. No, don't just focus on reforms to the adversarial system, think about inquisitorial. So I wrote a 452-page report for that committee, which included an analysis of inquisitorial systems and how they work in places like, Denmark, France, Germany, and so on. And some systems have a combination of adversarial and inquisitorial processes. I think at the end of that, we decided as a committee that it just would, it wasn't necessarily the shape of the box or the shape of the system, it's what happens within that box, or it's what happens within that system. We thought that there could be certain practices adopted from inquisitorial systems, like a specialist examiner, and there was sufficient compatibility with those practices and our own adversarial system. And remember, we were from 8 jurisdictions, all 8 jurisdictions were represented on the committee. We felt, and we did, we made recommendations to adopt certain practices, but not a wholesale kind of movement towards an inquisitorial system. So since then, all my work has been based on the idea of rethinking the adversarial trial. I mean, the US is streets ahead of us in this regard, as is Canada. I conducted a study tour of New York specialist courts. So New York has specialist sex offences courts, and there were judges on that, both Supreme Court district judges, barristers, and it was an incredible, an incredible tour. But when you bring back that sort of information, the political climate has to be right. And why had things worked in New York, for example? Because they had a state attorney general who made it his particular goal or passion. Why hasn't it happened in Australia or let's talk about New South Wales? Because we haven't had that kind of interest at the top until the very last Attorney General that we had, who was Mark Speakman, who was terrific in terms of... And so more reforms to the sexual assault trial were introduced under his leadership than had previously been the case. Back in 1991, there had been wholesale reforms led by the WA Attorney General in Western Australia. And believe it or not, in the very early 90s, WA was the very first jurisdiction on the East Coast. We didn't know about it, but WA was the very first jurisdiction to introduce the concept of CCTV, so to enable complainants to give... It was children initially, children to give evidence from outside the courtroom, from a room that was remote from the courtroom with a support person, those kinds of things. So things do happen, but it's piecemeal, and you need political will, but more than political will, you need someone who has a passion for these reforms.
Thank you, Dr. Cousins. Yeah, it's a shame in this country. There's so many countries do so many things so much better, and all we have to do is copy some of them. It's just that we need to look around the world and see what works and adopt best practices. My next question goes right to the heart of it. I'll direct this one to Professor Lumby. And Ross and I were talking before the forum started tonight, and we were talking about things that are reported in the media and sometimes not reported accurately in relation to sexual assaults. There's often a lot of falseness to them in this age we live in of false information. So the question is quite simple. Should the media be banned from reporting on all sexual assaults? If so, why? And if not, why?
Well, I can recommend a book by a woman called Jane Gilmore, which is funny but serious. It's called Fixed It. And she had a Twitter feed and she went through headlines and commentary on sexual assault and she fixed it, which I think is fantastic, right? But look, as a former journalist, one of the things is at least mainstream journalists are trained in court reporting. So I just want to say a couple of quick things on that. Now, I mean, the other area of my research that I didn't sort of allude to tonight is social online media research. I've done a lot of research into hate speech online, which is a pretty awful topic, but important to research. We know that we live in an era now where democratically it's great. Everyone can produce and disseminate their own media, but the sort of optimism we had about that maybe a decade ago is fading. So that's one thing. But I want to just circle back and say this about a couple of things that have been said. You know, I went to Sydney University Law School out of Newcastle as a girl from a working lower middle class background, and I was in shock, quite frankly, landing in the sandstone quadrangle there. And, you know, and this is not having a go at my male colleagues from law. I was yourself, both of you included here and others in the room. But, I mean, it was overwhelmingly white privileged men. I remember when we were studying criminal law, is my memory, allegedly, but this is my memory, the college boys from St Paul's or Andrews, one of those privileged colleges, brought in a plastic blow-up sex doll for the lecturer to hold. This is right around the time we were studying sexual assault, right? And that was a ha-ha moment. So, I mean, I think part of the problem with the system is that it is still, we live in a gendered society, it's still, I am now upper middle class, it's still people like me who get the podium, you know, and what you're in the business of getting other people to speak. And the second thing I wanted to say is, and I'm probably not answering your question, but I'm going to say it anyway, is that we've got to start young with education. And part of the problem is whether we're talking journalists or people on social media or people on juries, you know, when my kids were in daycare, I started explaining consent to them. And I said, if someone, you want to play with someone's toy, you have to ask them first, and if they say yes, it doesn't mean that you can play with it forever. If they want it back, give it back, and you can't take it home or break it. And we can start very young, and I think with rape myths, which are really powerful issues with juries, they are issues with judges, and that's where I'm going with talking about the sort of, some of the guys I went to Sydney Uni with, not all of them, that there's a sense of entitlement and privilege. And we're still in the business of deconstructing rape myth acceptance and educating young people in the family, in schools, in other places about what active consent looks like. And the reality is most people still communicate sexual consent non-verbally. Well, when you're first in an intimate encounter with someone, you need to learn to use your words. You need to know what you want, and you need to ask about what they want. So I'll shut up now.
Don't quite know if we got to answering the question, but that was very it was very informative.
Okay, look,
anyway.
Very quickly, I'll just say mainstream media, I mean, at least they're trained in court reporting. But what happens in the court is what they report, and what people read. One of the problems is they'll read what the prosecution says, then they'll read what the defence counsel says, and that's a problem, right? But the reality is, look, so I mean, in the social and online media era, most law is not fit for purpose. Contempt of court laws are not fit for purpose. You're going to drag 50,000 people off Twitter and tell them you're all in contempt of court for tweeting about someone who's accused of sexual assaults priors? You can't do that. So we actually need to look at where the law is fit for purpose, and bad law is law that does not work.
Thank you. Kerrie Thompson, you identified certain issues that happened back in the early stages with some of your client base in relation to police. What are some things that you can think of that would go some way to countering some of those issues?
Yep. Well, I just on what Simon said before about some of the quality of the brief and the investigations that happen, that happens with all crime types, and it happens from local police prosecutors, you know, who have said to us while we're at court, there's medical evidence missing, the OIC has not done a good job on this, and ultimately, you know, the case is sort of thrown out of court. So that happens, unfortunately, in a lot of crimes. But through, I guess, a lot of advocacy, particularly with Newcastle Police, we've got to a point where we're able to run a few sort of pilot programs. And as Simon says, it really does depend on who you've got at that time and whether they get it. So at the moment, the superintendent and the crime manager of Newcastle are absolutely victim survivor focused, and they want to minimise the trauma that people experience when dealing with police. So what they've implemented is that if someone walks into Newcastle or Waratah Police Station to report a sexual assault, the person at the front counter, whether it's the civilian or the GD, says, okay, all right, what we're going to do is I'm going to call a detective, and that detective's going to come down, sit with you in a room and talk to you about the entire process, give you all the information you need. So, please take a seat, we'll wait, call the detective. Detective has to come, it's not on the phone, has to be there, come in person, either down or across from Newcastle to Waratah. And sit with someone and say, right, this is the process of reporting. This is what this looks like. And then we make a statement. And then if you need a forensics examination, this is what it involves, and explains the whole process. And that detective that has that initial conversation takes the matter all the way through. So there's not someone reporting to a female officer and then it has a male detective. So we think that that's an excellent initiative that Newcastle Police have put in. It's 2 stations, 1 command in the Hunter region in New South Wales that are doing it. But we've got to try and make that change. And that's only occurring because the people in command at the moment are really understanding that the system doesn't work. They don't want to get police complaints, customer service complaints, and their biggest frustration is a matter gets to court and there's an acquittal or not guilty verdict. So we're trying to implement that, and we'll see how it goes. But that's a great step forward, and hopefully with me nagging the other commanders, we can get that process in the Hunter region.
Could I add just one thing to that? Some jurisdictions overseas have what they call a one-stop shop, so that people don't report to a police station, but they report to just a bland sort of building that is specially set up for sexual assault complainants, perhaps children and adults. I know there's a few places in England that have one-stop shops. Certainly they exist in various jurisdictions in the US, and what happens in the one-stop shops, it varies, of course, from jurisdiction to jurisdiction, is you will have police co-located with social workers, psychological support, a medical forensic team and examiners, and other supports that will assist that person with whatever their particular needs are at the time. I think we were trying to push for one-stop shops in New South Wales a few years ago, but they never got up.
Yeah. And that's a political issue too. We've raised that as well, and there's just not the interest. I've tried to get funding for that, victim support co-located with police. Police commissioner said there's no money for them. Victims commissioner says there's no money from them. So it's just not an issue, as you were saying before.
Can I just add that there's a lot of money poured into over-policing of the wrong things, in my view, and filling the jails with people who shouldn't be there, but that's a whole other bag of worms.
There you go, Ross. I think you've got the topic for your next forum right there. A bit of a Dorothy Dixer for you, Kerrie, once again. Are you adequately funded enough so that the people that have been victims of sexual assault are aware and have proper access to your services?
No. And it's a fight I have. It's an ongoing fight because we're not a domestic violence service. We're not a sexual assault service. So we don't get specific domestic violence funding. We don't get sexual assault funding. And we see men. So the funding that comes from Women New South Wales won't come to us because we see all genders of all types of violence. So we are a bit of a niche, which is good. But then, it does make us miss out on a lot of funding. We do what we can, but more money's needed.
Yeah, I thought I'd give you the Dorothy Dixer on that on the funding issue. I'm not sure how we're going for time, Ross, but it might be time to open it up for questions from the audience if anyone has one.
Many years ago I did a number of sexual assault matters, and I should put on record that I went to one of those 2 Sydney University colleges, as did one other gentlemen in this room who I will not name, and we both did law, or at least we both started law together. But I wasn't responsible, don't know anything about the sextile. One of my observations from having prosecuted sexual assault matters, and I did 2 trials involving child sexual assault victims, and committals involving 2 adult females and a magistrates court prosecution of a disabled woman. I would like to extrapolate on the comment that the facilitator made about, quoting Nick Cowdery, about the equality of the advocates. I would like to extend that to the equality of duty to the court, because in my observation, the greatest difficulty is suffered by complainants when the defence counsel goes for broke and ignores their duty to the court. And the other observation I would make is juries are treated like mugs. And in one jury that I saw where the result was just absolutely absurd, it was 11 old white men trying to judge a case involving an attractive young woman. I don't know what they were thinking when they came out with the verdict. It was just a disgrace for anyone who knew anything about the case. But the jury was given much more role in relation to the direction of the questions. I think you get a better outcome.
Hi, my name's Anusha. I'm a forensic examiner at the Newcastle Sexual Assault Service and medical lead of our Hunter New England Sexual Assault Services. I just wanted to firstly raise people's awareness of the fact that there is a thing called a forensic examination. So if you or anyone you know has been sexually assaulted, it's really important that you can get to an emergency department as soon as possible so we can get that evidence. We now have a process called early evidence collection where we can actually collect evidence even if there's not a forensic examiner available, or the patient might have to travel to a site where there's a forensic examiner, to try and increase the chances of getting some of that evidence that is often missing. But the main question I had for you on the panel, particularly for Dr. Cozzens, was around rape myths, and I think I just wondered if there's potentially more opportunity for our medical experts to give evidence to try and dispel some of those myths, because I think part of what we do when we're in court is actually educating the court around the fact that the absence of injury doesn't mean an assault didn't happen. The absence of bruises on the neck doesn't mean a strangulation didn't happen, and I'm actually doing a PhD on this at the moment. But I'm just so often surprised that we don't get called to actually provide an expert certificate for the number of cases we see with fantastic, even when there are injuries and we've got fantastic photos or diagrams or a great story and a lot we could explain, or even just explaining why someone might freeze and not fight, why someone might have memory gaps, why someone might still not have an injury even though they haven't been sexually active before, that sort of thing. I'm just surprised that there's not more kind of request for us to provide these reports. It's something that we do as part of the health service.
Well, it's an excellent question. It's a question that I have done quite a bit of research on. Presented my findings to the DPP one year and was told, well, we don't really have the time and we don't have the money. So, I've known a lot of Crowns over the years, that is prosecutors, and often it comes down to the fact that you won't have the same prosecutor who ends up prosecuting in court as that won't be the first person who first, interviewed the complainant and or talked to the police. Briefs get, switched around at the last minute. Expert evidence. Look, some prosecutors will say, yeah, it's really important to have that evidence in, but we've just decided not to go there. It's become a little bit more common, but it's not as common as it should be. One of the reasons is also the fact that, and I wrote a paper on this with a couple of medicos a few years ago, is the fact that most forms of penetration do not actually produce any discernible injuries or evidence of penetration. So, particularly in an adult sexual assault trial, if the issue is consent, as in the defendant doesn't deny that sexual intercourse occurred, then the medical evidence is probably neither here nor there. Usually, there's quite a few studies that show that juries are persuaded. What they want is DNA. They want DNA. They want evidence of real injuries. They don't want evidence that there's no injuries. And if there is time and proper preparation, yes, I do know that medical examiners will be called to give evidence to say that lack of any injury does not mean that sexual intercourse didn't occur. They don't seem to put a lot of weight on it, unfortunately, unless there are very discernible injuries, or it's a case that doesn't turn on consent. In child sexual assault trials, it's often more important, because if there's evidence of semen or bruising or lacerations, then that at least shows penetration, because consent isn't a fact-in issue in a child sexual assault trial. So I just think, I think there's a real problem even before we get to court. I think there's a real problem, as you were saying, at the policing stage. There's a real problem at the prosecuting stage. There were moves to try and introduce a specialist prosecutorial unit within the DPP. I know that occurred in the Victorian DPP for a while, but then it was defunded. I know from the evidence overseas, in Canada, for example, and New York, that specialist prosecutorial units for sexual assault have much better outcomes. But again, it's a funding. Not all, but a lot of it comes back to funding. Yes.
Thanks. That's a really good question, but I can't remember the last time I did a case other than a consent case, because, as Professor says, expert evidence isn't relevant in those circumstances because the act occurred. But I can't remember the last time I did a case where I said we need an expert, you sit down, you speak about it, and in particular, if there's, say for example, no matter which side you're on, there's no evidence of injury, that needs to be explained to whoever's going to decide the case, one way or the other, because just because there's no injury, you just can't leave it alone. Someone's going to wonder about it. So calling an expert about it and explaining it is a proper way to go. There's no excuse from the system where, leaving aside the question of funding, as has been said, often the Crown prosecutor who first gets the case is not the one that we lost, is not the one who does the case. But that doesn't mean the first person who picks up the case shouldn't do it properly. That should just be a given. And the funding issue is a two-way street. The Crown authorities have a funding problem. Legal aid has a massive funding problem. So all of this might militate against my stance that I said before about not changing the system to an inquisitorial system, but they are real problems. But it gets down to basic tools. Do your job in all aspects. Well, so people will be ringing you then. But the importance of experts is that I just don't understand how practitioners don't speak to experts, because no matter what sort of a case it is, you've got to learn your subject. You can't go to court not knowing the subject.
Speaking to it, right, that better? Yep. Thank you. I was a psychologist for a number of years where I did a number of cases that went to court. And the point you just made about expert evidence, I found that the legal profession was in the main reluctant to use it in matters where there were experts available who sometimes were material witnesses and weren't asked for their expert opinion. On the other matter, though, this is to Professor Cousins, the matter of, you say you've done a lot of research. One of the great myths that seems to be needing research, and I wonder whether it has been, is how many cases have been prosecuted against men who are innocent. There doesn't seem, in my experience, I found a lot of men getting away with it, but I didn't find too many men who had been unfairly prosecuted. Because I recognise that to make a complaint, one has to be either brave or silly, because it's an arduous, really traumatising experience. Thank you.
Sorry, is this a question to Annie or me? We can both go. Well, Annie's done a lot more. Well, I mean, I think we've all done different kinds of research and we have different forms of experience. But, I mean, I'll just say this before I hand over. I mean, coming back to rape myth acceptance, I just want to leave you with this one thing in your heads, right? Because I do a lot of work. I have a consultancy along with my day job as an academic, and I do a lot of work on gender equity and respectful relationships in the workplace, and what does that look like? And one of the things we know is someone going in and lecturing people about stuff, putting people into, well, you're likely guilty and the rest of you are potentially good people, is a recipe for disaster. What you need to do is get conversations going. But one of the exercises I do when I have a group of men and women is I put them in separate rooms and I ask them to write down on a whiteboard everything they do every day to avoid being sexually assaulted. Now, I can tell you that particularly with young women, they will give you a list of 30 things. Now, anyone want to hazard a guess about what the men come back with? Because it's one thing. Yes? Zero alcohol? There's one thing, they say avoid going to jail. And they say their big fear about going to jail is getting raped. Anyway, I'll hand over to Annie, who's got more of the stats to hand about the guilty innocent thing.
Yeah, that's another myth that's quite prevalent, I think, in our society, that most women who complain about sexual assault are lying, or are liars or lying, and are doing it for various reasons, and indeed that's often one of the cross-examination questions that will be put to the complainant, particularly if he or she has made a claim for victims' compensation. But both children and adults are subject to that particular inquiry. There aren't any studies that I know of in Australia, but overseas studies show that something like between 1% and 6% of sexual assault complaints are false. I think our greater problem is not wrongful convictions, given that convictions are most unlikely in a sexual assault matter. Even getting to trial is most unlikely. I think our problem is wrongful acquittals. I think that's the problem. But we will never know. We will never know what those stats are.
Hi, I was wondering as far as the jury learning about the defendant, if the defendant has had any prior either convictions or being accused of being a rapist. I read in recent studies, recent looking at church people who had assaulted young people, that in the court, prior complaints and convictions were able to be aired in the court process. I'm just not sure what's happening in sexual assault trials now. Are they able to talk about the defendant's prior conviction? And, okay, so should they be able to talk about it? I did read an interview with a retired Solicitor General from New South Wales, whose name I've forgotten, a few years back, who recommended that that the jury should be told if the defendants had prior.
The answer to that's easy. It wasn't all that long ago that an accused character couldn't be maligned, if you like, by the Crown unless the accused raised his own good character. In other words, you couldn't raise in court prior convictions or the like. That all changed with the introduction of the tendency rule. And that is a whole can of worms. It would take us about 6 months to look at. And what it enables the court to do is to have evidence led of prior convictions or charges or conduct, so long as that evidence has a tendency, as a particular tendency in terms of enabling the trier of fact to come to the conclusion as to whether someone is guilty or not beyond reasonable doubt, to put it vaguely and generally. In jury trials, as you can all imagine, these are concepts that are very difficult to grasp. And when you do a jury trial these days and the judge gives directions of law to a jury, and tendency has to be directed about, what judges do now is they get counsel to agree on the wording of the direction. And I can tell you, I've been in trials where even I can't understand the directions. So I don't know how jurors are supposed to be able to do that. I just don't know. And one of the things, just as an adjunct to that, is that when I first started practicing, one of the great learning tools and education tools that we had access to was the jury post-trial. You could come out of a trial after verdict, and if it was, where are we? Here? So out of in Church Street, and you'd say goodbye to your client, or your client can go home or whatever, and you go across to the pub, and all the jury would be over there. So the jury and the lawyers would talk about the case, and you'd learn things that you didn't know. And I'd had jurors say to me, "Oh yeah, look, the telling point was X," and I'm thinking, I never even thought about X, and we'd got an acquittal, so thank God I didn't. But you're not allowed to talk to juries now. You've got to get special permission, and it was done recently in a study. You'd know, Professor, someone sought special permission to do a study. And that was you?
And a colleague.
Right. But I just think we should have access to this because, we're talking about the sort of discussion we're having now. Surely the participants in that form would be useful to that discussion.
Can I just add to that? When the Royal Commission into institutional child sexual abuse was running, a colleague and I got a large grant to conduct a jury study on that very issue. What is the impact of introducing tendency evidence into a child sexual assault trial? So we were allowed to get access to the jury rooms in Downing Street and Parramatta, and we sought participants from the jury pool, that is people who were called for jury duty that day but weren't subsequently chosen to sit on a jury and were allowed to leave. So for people who've done jury duty, you'll know what that was about. And they chose, they had the opportunity to say yes or no. So we had over 1,000 jurors who sat on it was a videotaped trial, but it was more or less a full-length trial. It had, everything that you would expect, that you would see in a child sexual assault trial if you actually attended a real trial. And then they were allowed to deliberate for about an hour to 90 minutes. So that had to be curtailed, or else we'd be there for months or years, and we'd never get our results into the Royal Commission. We found, and we actually videoed and we taped the jury deliberations. So they knew they were being taped and videoed, but that didn't seem to affect them, because what we found, number one, was that people took the task really seriously. They knew they were part of a jury study, not an actual trial, but they argued, they got upset, some people left the room in a huff, that kind of thing. But they took the job very seriously, and what we found is that they didn't always talk about whether they understood the tendency direction that had been given to them by the trial judge, but none of them misused the tendency evidence that had been admitted in trials. And we had a control trial with no tendency evidence, and then we had a series of other trials with different types of tendency evidence in terms of weak, medium and stronger tendency evidence. So it was on the basis of that jury study, that the Royal Commission then recommended that the tendency rule be amended under the Evidence Act only in relation to child sexual assault trials, and that amendment was subsequently adopted by the New South Wales government.
Can I just add really quickly, this goes to a media thing. I know we're wrapping up soon, but I was talking, I've got teaching a course in media law and ethics to media and communication students at the moment. We were talking about contempt of court, right? So if you're a trained professional journalist, you know about sub judice. You cannot reveal priors. And there was that terrible rape and murder of Jill Maher, an ABC journalist in Melbourne, was very high profile. And people went on Twitter and found out that the guy who confessed to raping and murdering her had priors, and they released this. And the judge came out and said, "Oh my goodness, you're all in contempt of court." At which point I laughed out loud, right? What are you going to do about that? And I think that if we're talking about the jury system, whether we get rid of it or we retain it for sexual assault trials, there's an infantilised idea. Look at the mistrial with the Brittany Higgins case. One juror brought into the jury room that was discovered by a cleaner who bumped the file, knocked it onto the floor, brought in information from might have been your research into what do we know about guilt and innocence in sexual assault trials, right? So to pretend that the jury, this fiction, that jurors are people who've lived on some fictional island, unexposed to any other information, seems to me ridiculous in the age of online and social media.
Yeah, would everyone join thanking the panel? There's a long-held maxim in our law that says we would rather see 10 guilty people walk free than one innocent person locked up. There's been a lot of changes over the years to that. I don't think those numbers quite ring true, but that's a bit of food for thought. And I'm an eternal optimist, and when I look at this particular issue and look how far we have to go on the journey, I look back over my shoulder and look how far we've come. When you look at the abolition of the corroboration rule, for starters, when we look at back over many decades, we are in a much, much better position than we were in the past. But it doesn't mean we're still not on the journey, and we still have a long way to go. Thank you very much for coming tonight.
Thank you, Greg. It's a privilege for Newcastle Institute to host an event and a discussion of such importance, and I just really want to thank you for your participation, for your
for your questions, for your attention, and we really appreciate it. I think it's of the utmost importance. Next month we are discussing another topic of utmost importance, which is the GP crisis. There's been a huge change in the role and function of general practitioners in our health system, and so that's something that we're going to be looking at next month. It is a matter of very significant public policy consideration by governments, and where do we go? There have been some changes announced in the budget last night, but next month we'll be looking at that issue about GPs in detail. But thank you so much for coming. Thank you to all those who are watching online. And could you once again please say thank you to Greg, to Catharine, to Kerrie, to Anne, and to Simon. We really appreciate your input. We really appreciate your time and sharing of your wisdom and counsel with us tonight. And thank you very much.